everyone. I am David Winkler. I have Fredrikson Byron, and we are here today to talk about five things that every startup company should know. First, we'll do a quick round of introductions, and then we'll jump right in. Again, I'm David Winkler. I'm a corporate partner at Fredrikson Byron, and my practice focuses on representing startups and investors in corporate outside general counsel advice and financing transactions.
I'm Noah Huisman, an associate here at Fredrikson Byron. My practice, like David's, does some startup stuff. I also do some on the merger and acquisition side, and then some general corporate as well.
Aleida Connors, a senior associate in the group. Work with David and Noah also on venture capital, startup work, and mergers and acquisitions.
And I'm Courtney Thompson, a senior associate at Fredrikson. My practice focuses on brand management issues that relate to trademarks, copyrights, and licensing matters.
So with that, we'll jump right in. So this is 5 things about 5 things, and thing number 1 is getting started. And so the first thing when you're getting started, obviously the question that everybody asks is, what sort of entity should I choose? Entity choice matters, sort of. And so why the sort of? So as a practical matter, the first thing to keep in mind is what's the most important is that when you're starting a business, is that you just set up some sort of entity so that it's not you individually entering into contracts, agreements, etc. And so that piece, the liability protection, is a huge piece of it. And it's also important that you get the right parts in the right bucket from the beginning, meaning that everything you're doing is in the name of the company. And so this gets important when you start to make filings, and then you start to, if you want to approach a bank, for instance, and get a loan, that's all in the right name. And so any entity that you choose ultimately is going to get that liability protection. There is a slight exception of a partnership, but I don't think we need to get in the weeds on that now. So we'll stay high level and say the main choice that we see often is people asking between LLC or corporation. Now, if it's a true startup and you anticipate kind of raising outside money from outside investors, it's kind of a no-brainer in our opinion, or at least my opinion. David, you can weigh in if you feel differently, but that Delaware corporation is the way to go for a number of reasons. A lot of times we'll get founders or startup companies or startup business owners, people that want to start a business, and they'll ask, well, what about double taxation? What about, I've heard that LLC is actually the way to go, but for some kind of nuanced tax reasons, and a couple other reasons, we suggest corporation. And so I'll just explain that a little bit. So the double taxation piece, basically, because especially if you're a startup company, you never have to worry about the double taxation because you don't actually turn off the revenue and issue a dividend. There are actually really large corporations that kind of fall into this. Think like Amazon. They've never issued a dividend. And they continue to actually lose money. So that double taxation never comes in. As a true startup, because you are reinvesting that capital and never issuing dividends, the double taxation feature actually never comes into play. Now with the LLCs, sometimes you'll have founders who come in and say, well, what about these pass-through losses? I want to take a deduction. Yes, that's true, and you should always consult a tax advisor on those points. But at the end of the day, if you were to hard circle the amount of tax that you anticipate or think you would actually save going the LLC versus corporation route, unless you get some sort of meaningful deduction, which actually isn't the case most of the time, it's just simpler to go corporation. With that said, it's not overly difficult to do a conversion later on. But if you can just set it up one way or another from the outset, that always is the easiest. Anything I missed that you want to add?
I think that, a couple other basic points. If you're just a solo founder and you're just getting off the ground, a lot of times it's fine to use LegalZoom and just really to emphasize Noah's points, really just getting that entity up and formed. It's really when you have multiple founders and you start working through some of the terms we're going to talk about shortly that it makes sense to typically engage someone to help you talk through the different scenarios and alternatives. So yeah.
Yeah, and the only other thing I guess I'll mention is that if you anticipate raising money from venture capital, they're going to require you most likely to be a corporation, right? And that's the reason for that. Again, another nuanced thing is because a lot of their investors are nonprofits or other entities that can't get the flow through of the unrelated business income tax, and so they'll need to be a corporation for tax blocking purposes, which is another thing to consider.
I think I've seen quite a few people say you can either set it up as a corporation originally, or you can pay me $10,000 or $15,000 to convert it to a corporation when you get ready to do a financing. And so, if you're going to be that high growth startup, high growth tech startup that's either going to grow fast, raise capital, and fail or burn, it makes sense to be a corp from day one.
Yeah. Yep. And it gives you some more flexibility with equity too when you get into that. But point number 2, kind of in the formation stage, is on founder vesting. And so what we say here is founder vesting is a must, and it's at least a must to consider. Nobody wants to think that relationships can sour, but the reality is they do. And so what you want to do is you want to create an incentive structure that basically compensates somebody to stay and continue doing work. And so what vesting will do is typically you'll set it up in like a 4-year bucket, and you'll say on year 1, 25% of your equity you'll vest, and then it'll vest 1/48 for the remainder of the 4 years until at year 4 if they stay, continue to provide services, continue to be employed, whatever. So then that's the point at which they are fully vested. And to the extent that they stop providing services before that, then the company would have the ability to repurchase that equity at kind of the nominal value that it was originally issued at. And so, anything else to add there, David?
Yeah, I mean, the real world example is the 4 of us do a startup. We all decide that we're going to contribute the same amount, and we're going to be 25% owners. 6 months into it, Aleida is the only one still doing the work, goes out and raises capital, really puts in the work to create a company. And, 3 years in, the 4 of us still own an equal amount of shares without vesting, and, obviously have contributed vastly different amount of effort and energy to the company.
And then with that, I'm now going to kick it to Courtney to talk a little IP.
Thanks, Noah. So now that you have the entity and your founders vesting and whatnot, from an IP perspective, I think of that entity as kind of an empty shell that you need to put things in. And one of those things is the intellectual property that the company holds or will hold, including trademarks, copyrights, patents, and know-how. And the way you accomplish that transfer is through a written intellectual property assignment agreement, which is typically a pretty uncontroversial document. But a company really needs to be vigilant in getting this assignment from its founders, its employees, and really any service provider that will be creating IP for the company. A failure to get the assignment could mean that the company doesn't actually own the IP, and this can be a major sticking point for a transaction because investors and acquirers will request evidence of ownership, and assignments are often recorded against registered IP that the investors and acquirers will look at because they're public records to confirm what we call a clean chain of title, so that you see it from initial inception to current owners transferred down the line. You want the entity to be the current holder. In some cases, if you're hiring kind of outside guns to help bolster or create your IP, you'd be engaging a consultant, and this consultant may request carve-outs or grant-back licenses to the IP. For use of the consultant's background IP, so pre-existing works, this is usually fine, provided that the company has a broad license to use the consultant's background IP that is not assigned to the company. But a carve-out or grant-back license for the developed IP, or in other words, the IP that was specifically created by the consultant for the company, should be approached with caution. A carve-out or grant-back license for the developed IP usually comes at somewhat of a discount or a price break because if you think about it, the company is effectively subsidizing the development of IP for others. So if the carve-out or grant-back license for specifically the developed IP can't be avoided, we typically seek to restricts the consultants from licensing that developed IP to competitors of the company. The idea being that we basically want to limit the negative impact of that type of grant-back license or carve-out has on the company. And that's all for this slide.
Number 2 of the 5 things is raising money. And so this is kind of the stage where you have gotten to the point, you have a proof of concept, you've gotten your entity formed, and all of a sudden you're starting to think about issuing equity to outside people or third parties. And so this is some of the things you need to think about in that context. The first subsection of this is a securities law point, and that's generally it's illegal to sell stock, units, or notes, except when it's not. And so what that means is under securities law, what you have to do is you have to find both a federal and a state exemption to securities law. Securities laws exist. I feel like they got really robust after Enron and kind of some of the Dodd-Frank stuff, where the government started to be worried about fraudulent investments and people kind of defrauding folks. And so they set up these rules and said, hey, you either have to register or file under securities laws so we know what's going on, or you have to find an exemption. And the driving decision before you issue equity to somebody is one, do they meet one of these exemptions? And we'll talk about them a little bit more. But 2 is what securities laws apply in terms of what state. Federal will always apply, but what state applies is determined by the state where the investment decision is made. And so that's the identity of the buyer and their location versus the type of security sold. The only other thing I'll mention here is I feel like a lot of times what we run into, and understandable just from the practical realities, is that a lot of kind of startup companies, when they first raise equity, when you do the federal exemptions, they're relatively easy to find. I feel like in clients that we work with, a lot of times you'll make a filing that'll get you into some sort of safe harbors where you don't have to worry about whether you're in compliance or not. And a lot of times, companies we work with will make the practical decision that it's just an administrative burden, an expense that they don't want to bear on the front end, which is fine. And like understanding the practical reality of it, but it's important to be very aware of the risks when you do that.
You can do some public solicitations, but there's information requirements and other restrictions. And so, again, there's various buckets you can kind of fall into. The easiest way to comply with securities laws is to not do a public solicitation and to limit your offering to accredited investors. And a lot of times we have people say, I really want to add these non-accredited investors because I can't close enough money with the accredited investors. And our typical response is, there can very often be very significant information requirements that you will owe those non-accredited investors. And it becomes a lot more costly to issue securities if you issue to too many of them. And so furthermore, accredited, non-accredited is you're an accredited investor if you have $1 million in net worth, excluding your primary residence, or $200,000 of income, $300,000 if married, filing jointly. The last thing that we sometimes get questions about is, what about crowdfunding as a source of capital? Again, with that, if you actually do an equity crowdfunding and versus like a product crowdfunding, so actually an equity crowdfunding where you go out and you raise money from a couple hundred people and put them on your cap table, you have to ask yourself, do I really want to have to give updates to 200 people? Do I really want to, have 200 people asking me how business is and checking in and those sorts of things?
200 shareholders?
Yeah, the answer is probably no.
So now that we've gotten the fun security stuff out of the way, now we move to actually the different kinds of equity. And so there are notes, safes, common stock, preferred stock. Point being, this is a discussion to think about and have with your lawyer because there are benefits and drawbacks. But with the increased standardization of documents, it's all becoming relatively cheap and efficient. And so, which is good for everybody. The one thing to remember is basically, at the end of the day, all of these structures kind of result in the investors getting their money back first, and then the founders kind of getting the residual, whatever's left.
Where we see people get in trouble with notes is, you know, they work really well for a round, maybe two. The problem we founders and we see with somewhat frequency is, you know, they issue $500,000 to this group of investors, and then 6 months later they issue another $500,000 to this group of investors. Then another 3 months passes, they issue $250,000 to this group of investors. You get to the end of the line, they do a price round, and at the end of the price round, they own 20% of the company, and they had no idea how much they were selling in the meantime. And you know, and that actually happens. I know it's somewhat hard to believe, but so you really, you know, the safes and the notes, you know, oftentimes you have people, you know, and investors, or they kind of think they're cool because you can avoid legal fees, or you know, you can basically do them, you know, just download them off a website, fill in a couple things, and you're good to go, which is true, but if you're not thinking about how it all plays out, and how it all fits together when they convert, you can quickly run into some serious problems.
So the next point kind of goes to what I was previewing earlier about making sure you want to know, stay up to date with your capitalization. But one of the things that comes up often, especially as you start to approach VCs or other folks to try to raise money, is going to be this concept of pre-money versus post-money. And so my favorite illustration of this is, a lot of people are familiar with Shark Tank. And so somebody will come into Shark Tank and say, I'm looking for a $1 million investment for 25% of my company. And so if you run the quick back of the napkin math, I had to throw in the napkin theme there. If you do that quick math, right, what they're saying is post-money, my company is valued at $4 million, because for $1 million, you will receive 25%. And so post-money is $4 million. Pre-money, that means that technically today, without their money, your company is valued at $3 million. Post-money, $4 million. Pre-money, $3 million. And why that matters is when you get into the term sheet talk and they say, it starts talking about, hey, we'll invest this amount of money for at this valuation pre or post-money, that makes a difference, right? Because 25% of $3 million is a lot different than 25% of $4 million in terms of the percentage ownership. And so it's important to know and be clear in term sheets. I think being clear is probably the most important thing. It also will come into play when you start to think about the option pool that's going to be put in place, but just making sure that the expectations are clear in terms of when you start talking numbers with potential investors, whether their investment and their assumptions are made on a pre or a post money basis. And that's kind of when you're raising money. So last piece we'll mention is this kind of gets into assuming you elect to use kind of the standard NVCA documents, or even if you don't, then most of the investors' rights are relatively benign, but the ones to be aware of and hone in on are kind of those related to giving up board seats, what sort of protective provisions that you give out, and then obviously the liquidation preference. And so I'll just touch on some of the high points. Well, I just said assuming you use NVCA, and then the first bullet here is convertible notes. And so obviously for a convertible note, you wouldn't do the full slate of NVCA, investor rights, voting agreement, ROFR. You wouldn't do those. But on the convertible note, what you want to be careful of is we see situations often where convertible notes are issued, and then what you want to avoid is having a set maturity date, because then if it turns out if you didn't raise a financing in time, then what you have to do is you kind of have to get consent to extend that maturity date. Now, in practice, I don't know that I've ever seen that become an issue. It seems to always get kind of extended, but it's just an administrative burden that's a lot easier to avoid if possible. So switching from the convertible note to the traditional NVCA, and then we're talking investor rights agreement, voting agreement, ROFR agreement, which are essentially like three branches from a stockholder agreement, three separate pieces, but it's all kind of can be characterized as stockholder agreements. What's going to happen is investors will get, so there's going to be in the charter, it's going to model the liquidation preference, and far and away the market is you either get a one-time your money back, or the ability to convert into common and then participate that way. It's not an and so that's important. If it was an and, it'd be called participating preferred, and that is, I personally have never seen that in a deal. I'm sure you have, David.
Yeah.
But it is very rare, and it requires a situation where the investor has a ton of leverage.
It's just a pricing mechanism
Yeah.
for the day, right?
Yeah.
Yeah, just a good point. I mean, it never really comes up, but at the same time, it is just a run through the waterfall. If you got a high enough price, I suppose you could have it be indifferent.
Yeah, 100%.
Yeah.
Yeah.
But to your point, it's very rare, and, you know, particularly, I think one other thing, you know, it's really, really rare at earlier stages, because whatever we set for this round, the next round is going to ask for the same exact thing. And
Yeah.
so it's usually not even in the best interest of the investor.
Kind of running through some of the various other things I wanted to highlight. We talked about liquidation preference. The other one is the control of the board of directors. I think typically, especially at the beginning, we see one of two things. You see either two founders and an investor making a three-person board, or it's kind of a founder, investor, and then an independent, I think, are the two iterations I see the most. And what's important there, obviously, is the board of directors is going to have to make any of the sort of more meaningful decisions in terms of resolution. So it's like increases to the option pool, sale of the business, kind of some of the more extraordinary things. And that's kind of dovetails into the protective provision piece that is going to be detailed in these stockholder agreements. Specifically, what that's referring to is there are going to be certain things that the investor wants essentially a veto right over. But point being, as a founder, it's important, obviously, that you're able to run the day-to-day business. And so to the extent you can avoid like unnecessary expansion of what's in the NVCA documents, it probably makes sense to do so, just so you can continue to run it. That said, that's one of the benefits of standardization, is that these general protective provisions that are in the NVCA are kind of generally, they're accepted as market, and so they're not really that hotly negotiated in my experience.
Yeah, I mean, there's the director approval ones are the ones that you negotiate with,
Yeah.
right? Like, so I think the protective provisions, there's kind of like the big fundamental matters, selling the company, maybe issuing senior preferred stock, repurchasing stock, trying to get around the liquidation preference, some basic protections around the investment. And I think those aren't very controversial, but, you get into more operational things, and those can be rather heated, because at the end of the day, from a company perspective, we want the founders, we want the people in charge of running the business, making the decisions and the operational decisions. If it's something truly fundamental, I understand the protective point a little bit. I always have someone always remind me, whenever we say the NVCA is standard, it's written by venture capitalists.
Oh, yeah, sure.
Yeah. It is the National Venture Capital Association.
Yeah.
So they love to have it be standard, where they get all the protections in the world. That means, and Noah's absolutely right, that, there are quite a few provisions there that aren't very controversial. But when you start to get more into the operational things, and, specifically control the board, there's a lot of variances within those documents, who's really running the company. In a perfect world, you've got 5 or 10 term sheets, and you should be asking for references for the investors. You're particularly at the seed and Series A stage. Once you bring somebody onto the board, once you bring them on and you start giving them these sorts of protections, they're going to be there until exit. And you are adding, and when you don't like that person, or when they ask for a bunch of information every 2 weeks to get updates, the relationship can sour, and it's not fun working with people you don't want to work with. And there's really, once you bring them in the cap table, there's really no getting them out until a sale.
Yeah.
Now you've got a little bit of cash, and you've formed your entity, and you're ready to build your team. So number 3, building the team. you're going to bring folks on, you're not going to do this on your own. And so first thing you do is you hire someone, and when you hire them, are they an employee or are they an independent contractor? It makes a difference in the way that you pay them and in the benefits that they may get. But just know that you can't decide that arbitrarily. You can't say it's better for the company to have this person be a 1099 independent contractor, and so everybody's going to be an independent contractor. The IRS has a list of criteria that they look at in making that determination, and at a very high level, it's going to depend on how much ability that person is getting to do the work independently and on their own time and for other people versus solely for you at the times you designate and the places you designate. So keep that in mind when you're bringing people on. You want to make sure that you're classifying them properly. It's a problem for the company if you end up classifying everybody as an independent contractor, and it turns out that they should have been an employee for a few reasons. The employee can come back and say, hey, you misclassified me, and so you owe me, wages for the misclassification, and so you're facing a lawsuit. Or the IRS can come in and take a look and say, hey, you were supposed to withhold taxes from this employee's paycheck. You were supposed to pay your employer a portion of taxes, and you haven't been doing that. And you can see as you accumulate employees over time how that can add up throughout the years and increasing your workforce. So make sure you get that right from the get-go. If you have a question, talk to your lawyers. We're here for. Another recurring theme of this presentation you'll note is IP assignments, and so I'm going to kick it over to Courtney for her just recurring reminder.
Yeah, so another reminder to get the intellectual property assignment agreements, and that would be included for employees. Ideally, you'll get these assignments at the time that you hire the employee. If you already have hired the employee and haven't gotten an assignment, then you need to give additional consideration in exchange for the assignment in order to make the agreement enforceable. So the actual dollar value or incentive can vary, but it does need to be there if it's post-employment date. For employees, Minnesota state law and other states also require statutory carve-out for any inventions that are not in the line of the business or created with company time and materials. And the purpose is really to clarify the scope of the assignment for both the company and the employee. So just because they're your employee doesn't mean that you own anything and everything that they do, even on their own time with their own materials. The assignment provision can and often is included in a confidentiality agreement or a larger employment agreement. So just a quick note on each of those. For confidentiality agreements, the agreement should reference the Defense of Trade Secret Act, which was passed a few years ago, which makes an exception to the employee's confidentiality obligations for whistleblowing purposes. And for non-competes, even if limited in time and scope, should be entered into really only upon the advice of your attorney, because the permissibility does depend on state law. By way of example, a non-compete in California can invalidate the entire agreement. So it's something that is to be tread upon lightly.
Number 3, equity grants. So one nice thing about having the ability to issue stock to your employees is you can let them participate in the upside of the company. It's a nice motivator. And so a lot of companies do issue equity, particularly to key employees, to keep them invested and keep them motivated. You want to make sure that any of those grants are subject to vesting, and you don't want to give a service provider some stock right away that's intended to compensate them for 4 or 5 or 3-4 years of work, have it vest right away, they quit in 6 months, and they've got all of the compensation that was really supposed to be spread out over 4 years or whatever it is. And so making sure that that those provisions are in place is important. The other piece here is accelerated vesting, and sometimes service providers might ask for stock that accelerates. The vesting accelerates on a sale or liquidation event. And so what happens is upon that event, say that their stock was supposed to vest over 4 year, event happens in year 2, they've vested in half of the stock, they want the other half to vest immediately. Investors don't really love that because you've taken away the economic term of the company was supposed to get 4 years of service for that vesting, and now you've shortened it to 2. And so try to avoid those if you can. Investors won't like to see them and might ask you to get them changed if they're going to come in and invest and you've got that in your stock plan.
Yeah, I mean, the only thing I'd add is that the typical stock plan we see here is, you know, at time of sale, the board gets to decide based on what the sale looks like, whether to accelerate everyone. If it's a really good sale, you know, and they don't need the people to stick around, the board will typically accelerate everyone and pay them out. But what Aleida is saying is it was, you know, when you've got the scenario where you're 2 years into a 4-year vest, we have a sale, the new buyer needs these people to stick around, we can say, hey, in order to get the last 2 years of your stock you've earned and the value associated with that, you need to stick around here for 2 more years. If we don't have that, what happens is, and it automatically accelerates. They get paid a bunch of money, and the buyer says, I need these 2 people, and these 2 new people say, I just got paid a bunch of money, I don't want to go work for this person. And the buyer says, okay, well, that's your problem. I'm buying a business. I need these people. I need to create a pool of $2 or $3 million, and that is no longer going to be payable to the stockholders. That's going to be payable to these people to get them to stick around for 6 months and help me transition. And now, as a stockholder, investor, you're like, great, I paid them 4 years for 2 years, and now I've got to pay them another, you know, $2 million for 6 months. I'm getting dinged coming and going.
And it becomes a problem for your sale too, because then you have to get them to stay the extra 2 years. What if you don't want to? You have to deal with that issue. So.
Exactly.
Number 4, avoid severance except when you can't. You are not legally required to give your employees severance, and so don't offer it unless somebody asks. And obviously, if they do, then you can have a business discussion about that, but it's not something that you should be just putting out there and offering to all of your employees. Relatedly, make sure that that's saved for, you know, valuable key team members. It can be a good tool when you've got somebody who really should be on a non-compete and you're having, you know, maybe their appetite for signing a non-compete is not great. The severance could be a good sweetener to get them to agree to that. And then kind of along with that, don't put in your employee handbook. You don't want to create some precedent for giving out severance when you don't have to, and you don't want somebody to come back and make a claim that they were entitled to it because it's in your handbook, whether or not they deserved it or should have done it. And then lastly, number 5 on termination, because employees don't stick around forever always. There will be terminations. Try to get a release if you can. It's not that they will sign it each time, but if you can, it will save you some headache on the exit side. It's typically a mutual release, and so basically that will say, I, the employee, don't owe you, the company, anything. You don't owe me anything. We're all good, and we can all walk away from this. There are timing questions around this one, and so it's good to talk to your lawyer when you're going to get a release from employees. Once you give them the release, there's a certain amount of time that they've got where they can essentially, they've got a certain amount of time to review, and then once they sign, they've got a period where they can walk it back. So you want to make sure you're following the rules on those. If you haven't given them a severance yet, this might be also a good time if you're having a hard time getting them to sign a release to offer a severance with that, although that could be a little bit of a double-edged sword because some people think they've got a claim when they don't. So I don't know if either of you have anything to add there. That covers number 3 on the team. Number 4, protect your ideas. Courtney.
Yeah, thanks, Aleida. So you can advance to the next slide. I don't think I'll be surprised to you all that we'll remind you again to get an intellectual property assignment agreement from those that you're working with. The magic language that courts look for is a present grant of rights. So most commonly this is expressed as person A hereby grants to person B all rights, title, and interest into the IP. So what's not valid is a future grant or a promise that you will at some point assign your rights. It needs to be the hereby grant, the present grant. That's important. So we'll touch quickly on open source software. The topic of open source software can make investors and acquirers a little bit jumpy. And in general, we see less concern when the open source software is used for back-end and administrative type functions for the company, but it can be a bigger deal when the open source is used for the customer-facing or core products of the business. As a result, it's suggested to have a policy in place regarding when and how open source may be used within your software and operating the business, along with tracking and documentation requirements for those developers. Like a lot of things that we've discussed, it's about keeping kind of a paper trail and being cognizant that you're following those policies so that you know when and where the open source was used. You can advance to the next slide. So as a bit of background, there are three main buckets of IP. We have patents, trademarks, and copyrights. Patents are for new, useful, non-obvious inventions. Trademarks are for words, names, symbols, and devices that indicate source or origin. And copyrights are for original creative works that are fixed in a tangible medium. So one product may have a useful function, is patent eligible. It has a product name slapped on it, which is trademark, and then it has packaging that has coloring and swirls and all of that, which would be copyright protection. So oftentimes the product, and in some cases the service, will, components will fall into each one of these buckets. Patents are essentially a government grant of a limited monopoly to protect or to practice that protected invention for a period of 20 years, which is why they can be quite attractive and valuable. And if you're the only one in the market, you can charge a higher price. One key to remember when evaluating whether you want to file a patent application is that there's a 1-year on sale bar. In other words, you have 1 year from the time that you disclose your invention to file a patent or a provisional patent. And because of this time bar, it's really essential that you connect early with a qualified patent attorney so that you don't let your rights go. The kind of flip side of patenting is keeping your invention as a trade secret, which isn't always possible in all cases if it's kind of right there as your product. But for trade secrets, the key is that you do treat it as a secret. That means you're vigilant about using confidentiality agreements and otherwise treating it in a protected manner if you're not able to get the patent protection for the invention. So number 4, it is important to regularly use confidentiality agreements even if you have other IP protection. These agreements are common and should be used with employees, contractors, distributors, resellers, really any partner or third party that your business is working with. And savvy players will frankly expect to sign one, and that would include potential investors or acquirers. For most B2B non-disclosure agreements that we review, they're mutual in nature. So in other words, they protect the information of each party. Although usually when we're working with startups, we provide them with a template. One would be mutual, protecting each party, and then one would be unilateral, we would say, where you would give it, for example, your employee, saying that the employee needs to protect the company's confidential information. The employee doesn't always expect you to have that kind of reciprocal treatment of their information. So that's why it's good to have both in your toolbox to use, both unilateral and a mutual NDA. And then the final point in the IP section, so for the other types of IP that we've mentioned, we see that trademarks and copyrights are particularly important for brand-heavy companies. For trademarks, one of the biggest benefits of registering at the USPTO, United States Patent and Trademark Office, is nationwide priority, whereas common law rights only exist near geographic region of use. Registration also helps bolster the scope of the company's registered IP portfolio, which can increase the value of the company. For early stage and second stage companies, we usually recommend at least running a clearance search and filing an application for the company name, which may also be referred to as the house mark, and any core products or service names or slogans to protect those brands. Upon registration, you can use the R and a circle symbol that we see as the trademark notice. In the meantime, and even without an application, you can use the common law marking, which is a TM. And I think that mostly concludes the IP section of the presentation.
All right, so number 5, finding the exit, and that's what you want in the end, right, is to get your money out of this thing. So how are you and the investors going to get value out of the enterprise? Few things to keep in mind here when you're thinking about an exit. Kind of the typical exit most people think about is 100% sale. So some strategic or PE buyer comes in and says, I'm going to take your company and I'm going to fold it into my portfolio or my existing business. There could be more other things that constitute a sale, a liquidity event. A strategic buyer can come in. On the strategic buyers, we're actually seeing more and more investments on the front end that end up having an acquisition option and an option to end in a more traditional exit event. So just keep that in mind. Entity choice matters a little when considering exit against tax reasons why you might want to pick one over the other. Any other thoughts on this one? Hopefully at this point you've engaged your lawyers well before this point. Yeah. So speaking of that, do everything right and keep it in writing. When you get to, and you'll go through this as you have investors come in, you'll go through some diligence, various diligence processes probably. But definitely when you get to a sale event, the buyer is going to go through a diligence process. They're going to look at your company from inception to where it is now, and they're going to want to know that all your I's are dotted and T's are crossed and everything is perfect. And so one way you can avoid headaches for yourself later is as you go through the life cycle of the company, make sure that you're documenting everything, put everything in writing, and keep clean records. So example we've got up here happens pretty frequently. You're in the beginning stages. You're maybe working with somebody and you say, hey, if you write some of this code, you'll get X% of the company. The person flakes out or doesn't really write it, or they give you some garbage that you can't use. And then, years later, you never document it, they walk away. Years later, at an exit, they come back and they say, hey, where's my 5%? I provided services. And you really don't have much to go on at that point. At that point, you're going to have to come up with some agreement with them and likely have to pay them something to get it resolved because your buyer's not going to take on that risk. And so it's much easier if on the front end you had said, all right, this didn't work out, let's just get this in writing, or, you got X% for the work that you did do. Even worse if you use the code and then don't get it assigned to your company and you have a bigger mess at the end. Any other thoughts here?
Yeah, I just, to Aleida's point, the example we've seen in real life is, it's probably unpleasant enough dealing with the person when they're leaving initially, and so you're like, oh, I'll deal with it later. But I promise you their plaintiff's attorney later will be even more unreasonable. And, the example I've had is, oh, well, it said 5%, and I know that the company raised a bunch of capital, but, but then my 5% would be worth 2.5% now, but because I don't understand that, so I get 5% today.
Right.
And you're like, what world do you live in? And they say, the one that I'm right, and we're going to sue you.
And we're going to fight.
And we're going to fight so.
Yeah. Yeah, so to drive that point home, number 3, keep track of every single share, unit, and option. Write it down, keep clean records. Don't promise people equity and then forget about it. Don't promise people equity, period. Put it on, document everything and get it written down.
This is one last plug to get your IP assignment.
And then number 5, engage with strategic investors carefully. We talked about this a little bit on number 1, but strategic investors are coming in for a different reason than your funds, right? They're looking at this as something that's going to add value to their existing business in one way or another, and they're watching out for their existing business, not your venture. So your interests are not as aligned as a VC fund that's just going to come in and try to work with you and get 10x and make the most money out of this as possible. So keep that in mind if you're entering into a relationship with a strategic investor. Think about it more as a marriage that, once you let them into your cap table, as David said, you can't easily get them out. You don't want it to become an issue down the line when you're getting ready for a sale if you're considering another strategic investor as a potential buyer. And so you want to map these things out on the front end. A lot of times the relationship with a strategic investor is going to come with more than just a dollar investment. There are going to be commercial agreements that play in there. There might be licenses, distribution rights, that type of thing. And so map out those goals, make sure that you're aligned and that you're watching out for your company. As I mentioned before, we're actually even seeing strategic investors come in at an early stage with an intent to acquire, and that's a whole different animal. I'll take a quick minute to do a plug for our other Fredrikson session on September 17th at 9 a.m., and that's specifically on development stage strategic investments with acquisition rights. So if that's something you're interested in learning about, we'll be talking about it. I don't know, David, Noah, if you guys got anything to add here?
I don't think so.
No, I think the only thing what I would say is, you're probably, who your acquirers are. You probably do pretty quickly when you're growing your company, or certainly after you get it up and you're starting to develop. And so, we say engage with them carefully, and we mean that, particularly when they're coming on the cap table, but also engage with them. And, a lot of times we see acquisitions from 2, 3, 4 year long relationships where they meet each other at trade shows, they've tracked the progress of the company, they follow up, and then it comes to fruition, it's a natural fit, and they say this is the time that fits, you're far enough along where we can plug you in, and this is the time we like to acquire companies. So it's just one other point to consider. And the thing we don't like about engaging strategic investors on the cap table is exactly what Aleida said, which is, your interests can diverge quicker than you think, particularly the earlier you go. But she will go much more in depth on that on her discussion, and Aleida has completed a number of these strategic investor transactions, both from a company side and strategic investor side.
Anything to leave us with, or?
No, I think thank you all for your time, and we look forward to seeing you all in person next year.